Thank you for joining us this evening. I am Jennifer Dye, a librarian at Detroit Public Library. We've had a very strong program with the League of Women Voters Detroit for over 2 years now. We present on issues of concern to Michigan voters about 10 months of the year. You were brought into this program muted. Please put any questions into the chat. Ruth Coolwin will capture these questions and ask them at the end of the presentation. We might be able to allow people to unmute at the end of the presentation to ask questions directly. Dr. Caminker has, and I'm sorry, I forgot to check the pronunciation on your name.
It's Caminker.
Caminker?
Yeah.
Has requested that if you want a clarification on something, that you send a request to me, Jennifer Dye, to unmute you to ask the question. This presentation is being recorded, and it will be made available on DPL's and the Detroit League's websites. Deborah Bunkley, who is acting president of the League of Women Voters Detroit, will speak briefly about the League and the Detroit group.
Yes, Deborah Bunkley. I'm co-president with Sarah Warts, and I'm just going to briefly say our mission statement. Our mission with the League of Women Voters of Detroit, we also represent Hamtramck and Highland Park. Our mission is empowering voters and defending democracy. Remember, democracy is not a spectator sport. Our vision, we envision a democracy where every person has the desire, the right, the knowledge, and the confidence to participate in the democratic process. And our value, we believe in the power of women to create a more perfect democracy. And keeping in mind that democracy is not a spectator sport, you have to participate. And I'll move it on back to Jennifer.
Thank you, Deborah. Our speaker this evening is Dr. Evan Caminker, Dean Emeritus and Branch Rickey Collegiate Professor of Law at the University of Michigan Law School. He agreed to speak to us in March about the North Carolina question about whether the state legislature could overrule all courts, summarizing very unlegally. But then the North Carolina Supreme Court changed the party balance. And so we assumed that the issue was moot. The US Supreme Court just surprised many by deciding the issue on June 27th of this year. Dr. Caminker is joining us this evening to talk about the original questions and the implications of the court's decision. Dr. Caminker, thank you.
Well, thank you, Jennifer. Thanks to all of you who are helping to put on this fantastic program and to facilitate this evening's event. I apologize. I was having some technical difficulties earlier, so some of you may have seen me come and go for a minute, but I think we're ready to rock and roll here. I'm going to try once again to share my screen because I will have some PowerPoints. I am not going to try again to get rid of the border on the left because I'm a little nervous that that's what caused the problem. So please just don't look ahead. In any event, this is democratic elections and the independent state legislature theory. By way of background, I have spent my life really studying Supreme Court decisions. As Jennifer said, I'm a professor of law at the University of Michigan. I was the dean there for 10 years. I have done a lot of pro bono litigation. I have gone in and out of various different government roles. I actually participated in this case, co-authoring an amicus brief for a group of state court, Supreme Court justices who, for obvious reasons, as we go through, had a very clear interest in the case. It was actually an amicus brief that was referred to by a couple of the justices during the oral argument. So I harbor the hope that it actually was somewhat meaningful and relevant to them. And we'll see how that goes. I will say that much of my experience working on Supreme Court decisions comes from the fact that many years ago I clerked for this fellow whose name is Justice William Brennan. Many people think he's one of the greatest Supreme Court justices of the history of this country. Very liberal justice. Some people appreciate him for that. Some people dismiss him for that. He does have one distinguishing feature, however, that I think sets him apart from any other Supreme Court justice who has ever sat on the court, which is he has the largest earlobe to head ratio, which I think this picture pretty much shows. He obviously is no longer on the court. This is the current court. And if you look really carefully at this court, what should stand out to you is there are a lot of conservative credentials. This is the first time in about 100 years that we have had a court that is skewed as far as it is towards conservative ideologies. There are 6 what I would call solid conservative votes on the court, and 3 fairly solid liberal votes on the court. Sorry about that. And that means that decisions about democracy, about elections, about voting, there tends to be a concern about whether or not ideology will be playing some role in the interpretation of the rules of the road. And that's one reason why people were looking very carefully at this particular case. Now, this particular case is more against Harper, a case about, as Jennifer said, the so-called independent state legislature doctrine, which I'll explain in a moment. By way of background, a very conservative former judge named Michael Luty, who some of you may now know because he testified publicly before the January 6th House Committee representing Vice President Mike Pence, he described this case as, quote, the most significant case concerning democracy in the last 200 years. I actually might think it was behind one other, which was the case that established the 1 person, 1 vote rule, but he's not far wrong. It's a very, very important decision, or it could have been a very, very important decision. And that's why I think it's worth spending time on tonight. And again, I appreciate your involvement. By way of background, we need to remember under our federal constitution who it is who actually runs elections. And the answer is states. So this is the language in the federal constitution called the Electors Clause, which has to do with establishing the rules of voting for president. And the relevant text here says, each state shall appoint in such manner as the legislature thereof may direct a number of electors. And then it goes on to say, and this is how they meet together and how they register their votes for the president and the vice president. No, it doesn't say each state shall appoint. It says in such manner as, quote, the legislature thereof may direct. And that's the relevant language here. Similar language in the Elections Clause, which governs elections for Congress. This says the times, places, and manners of holding elections for senators and representatives shall be prescribed in each state, and then here's the relevant language again, by the legislature thereof. But Congress may at any time by law make or alter such regulations. Okay, so the question is, all right, this looks pretty clear. It looks like state legislatures are directly given the authority to establish the rules. How do we vote for members of Congress, and how do they appoint electors for presidential elections? So what? Well, the concern is, particularly now that we have highly gerrymandered state legislatures, where we have clear red states and some clear blue states, handful of purple states, that state legislatures can act and engage in some kind of, partisan shenanigans to control who actually gets elected to Congress or who gets elected to be the president. And the so-called independent state legislative theory builds on this exact language The most radical form of that theory says the state legislature and only the state legislature gets to control the appointment of electors and the elections for members of Congress. A less radical view would be to say the legislature clearly gets the primary decision-making power. And if anybody else gets to play a role, it must be a minor one compared to what the state legislature can do. Now, some of you should have been familiar with arguments about this theory stemming from the 2020 presidential election. There was litigation in the state of Pennsylvania. You may recall this going on about absentee ballots. Of course, the 2020 election was held during the pandemic when many people rightly had health concerns about standing in line and entering voting precincts to register their vote. And for that reason, a lot of people were planning on using absentee ballots. In the state of Pennsylvania, the state legislature had established that one could vote by absentee ballot, but that ballot had to be received by the end of election day through the US mail in order to be counted. As voting day approached, there were lots of worries. It was pretty clear that in the state of Pennsylvania, the number of absentee ballots that were being cast was going to far outstrip anything that had come before, because again, people choosing to vote by mail and not in person during the pandemic. And you may also recall that the post office announced several weeks before the election day that there was such a backlog and so many people voting absentee that the post office could not guarantee that ballots mailed even a couple of days before the election would be received on election day. So a group of voters went to the Pennsylvania courts and they said, hey, wait a minute, if the legislative rule that absentee ballots have to be received by election day is truly enforced, then a lot of people voting by absentee aren't going to have their votes counted. And that's a problem under the state constitution that promises a fairly generous so-called right to vote. The Pennsylvania courts, all the way up to the Supreme Court of Pennsylvania, agreed with the challengers and held that the state constitutional promise of a fair election trumped the legislative rules, and the state court on a 4-3 vote said it'll be fine as long as your ballot is postmarked by election day. It doesn't matter if it gets received a few days later, we'll still count. Now, that was one of the supposed rule changes that a lot of Republican candidates, Republicans like John Eastman, were upset about because they thought anything that makes it easier for people to vote absentee and have their votes counted is likely to help Democrats because more Democrats were using absentee ballots, partly because President Trump had actually told Republican voters, don't vote by absentee, you want to vote in person. So they took that case to the US Supreme Court. The US Supreme Court said, we don't have to decide this yet. Let's just set aside the ballots that Pennsylvania received after election day, because maybe there won't be so many that it'll matter. And at the end of the day, Pennsylvania had so many more votes for Biden than there were late votes. The court said, all right, we don't have to count it. Clearly, President Biden won't have to vote. But in the process of that litigation, several justices made side comments saying, hey, we think this may be fishy. We may think that this was an example of the state Supreme Court wresting control over the voting rules away from the state legislature in violation of the electors clause, as was discussed. So this kind of set up the background for a fight over whether or not the right answer is, does the legislature get to completely control voting rules, or in the context of presidential appointments, how to appoint electors, or can state courts play a role by modifying state statutes as necessary to comport with state constitution? Okay, now let's get to this particular case, which is more against Harper. Now we're going to talk about elections for Congress. Everything I said about Pennsylvania was about the presidential election. Now we're talking about the 2022 election for Congress. In North Carolina, the state constitution guarantees everybody in the state access to, quote, free elections. Obviously, very vague clause. The question is, what does that mean? In the state of North Carolina, it's a state controlled by a large Republican majority in the legislature. And the legislature has exercised its right to do redistricting in a way that very strongly gerrymandered the state so that it's almost guaranteed that Republicans will win elections for Congress, both in the Senate and in the House. A group of voters brought suit in state court, arguing that that political gerrymander violates the state constitutional rule that says elections ought to be free. And at that time, this is now back in 2021, the state Supreme Court ruled in favor of the voters. They held that the free elections clause prohibited exaggerated partisan gerrymanders and struck down the state's districting map and ordered the state legislature to try again to draw a more fair set of districts. The state legislative leaders appealed that to the US Supreme Court, and that's the Moore against Harper case. While, funny thing that happened on the way to the Supreme Court, you might say, and Jennifer alluded to this, while the case was pending Supreme Court decision, the state Supreme Court, there was a new election in the fall of 2022, and a handful of Democratic appointed or kind of Democratic affiliated justices lost election to Republican affiliated justices. So the North Carolina Supreme Court turned to a more Republican dominated courthouse, and they overruled their own state court decision saying that the state Supreme Court prohibits political gerrymandering. That's why there was a question about whether the US Supreme Court was still going to issue an opinion. But I'll leave aside the background of the procedures. The Supreme Court did in fact decide the case. What did they decide? Well, they decided in a 6-2 vote that they basically rejected the independent state legislative theory. In my view, that democracy dodged the bullet here. And they held that the elections clause does not vest exclusive and independent authority in the state legislatures to set the rules governing congressional elections. They make that state courts generally have the opportunity to review state laws for compliance with state constitutional provisions, and they held that the elections clause doesn't carve out any exception for that. With reference to the state legislature, we'll come back to in a moment, but they basically said that doesn't really mean the group of elected people who happen to be in the state house, the people that you and I might normally think of as state legislators. But what it really means is the lawmaking apparatus that a state chooses to create, which could just be the legislature, but could be the legislature as constrained by other rules in the state constitution, such as a governor's power to veto, and such as the Supreme Court's power to review for consistency with state constitutional rules. The court based its decision on a number of factors. They focused to some extent on precedents. They looked at 3 different cases. One is from 1916. There was a case where they upheld the right of state voters to use a referendum process to override the state legislature's redistricting statute. In 1932, they had upheld a governor's veto of a state legislature's redistricting statute. And in 2015, the only recent case, obviously, in the spring, they upheld an Arizona constitutional amendment that took power away from the state legislature to engage in the business of districting and put it into an independent commission. Those of you, perhaps all of you who are here from the state of Michigan, may recall that a couple of years ago, the state of Michigan adopted its own similar state constitutional amendment that likewise took power away from the state legislature to draw district lines and put it into an independent commission that in fact did redraw the lines for the last 2022 election. So those are the cases that the court said, hey, we've already decided these issues. Now, the state legislative leaders said, okay, look, we're aware of those cases, but those cases can be distinguished from what happened here in two different ways. And the U.S. Supreme Court considered but rejected both of those grounds. The first argument was all of those constraints were procedural. They had to do with things like whether the governor could veto a state statute. Arguably, that's still part of the legislative process. Or whether voters could exercise their power through a referendum process to override or modify the state legislative rule. Well, the referendum process can also be viewed as kind of part of the lawmaking process. So the challengers, the state legislative leaders from North Carolina said, yeah, we know about those previous cases, but all they meant is that the word state legislature means the process of the state legislature, including overrides and vetoes that go to the question of what is an actual state statute on the books. But those are different than saying the state Supreme Court can step in and basically say a state statute is unconstitutional. The Supreme Court rejected that distinction. They didn't provide any reasoning for it. They just said it's really a hard line to draw. When is a constraint a procedural one and it's a substantive one? Court said we just don't want to get into the business of limiting those previous precedents and all of that. The second effort that the state legislature suggested is different about this case from prior precedent is that in those cases, the state law constraints on the legislature was really clear. It was really clear in state law that the governor can veto any state statute, and it was really clear in state law that the referendum process allowed state voters to override certain kinds of state statutes. But here, the state Supreme Court relied on an incredibly vague constitutional provision, in this case, one that simply promised free elections. And in that context, we're worried that the state court is really just kind of making it up as it goes along. There's nothing to stop the state court from saying, just, we don't like the policy underlying the state legislature. We don't think it's appropriate for the state legislature to draw highly gerrymandered lines for partisan purposes. And so in a sense, we're worried that the state court is just replacing the state legislature's policy making with its own. And the Supreme Court rejects this also and says, we're not going to get into the business of drawing lines between what state constitutional rules are written in clear language versus what state constitutional rules are written in vague language. And that may reflect the fact that the U.S. Supreme Court itself reviews federal statutes for consistency with federal constitutional provisions that are pretty vague, such as equal protection of the laws, such as due process, such as cruel and unusual punishment. The point being that courts all the time apply language that is fairly general and fairly vague, and it didn't want to draw any lines in this particular context. Now, it's interesting that the court in this case did rely on stare decisis, because we all are aware of the fact that this current Supreme Court doesn't always do so. Perhaps the most famous case in which it didn't recently is the case Dobbs from 2 years ago when it overruled Roe v. Wade. It feels perfectly comfortable at times saying there's a precedent on the books, but we think it was wrongly decided. we're going to overrule it. So it wasn't a foregone conclusion that this Supreme Court would say, we're going to keep following the precedents that we think we have on the books. And that's why in some ways, this is it's this decision that a lot of people were worried about, but might actually go the other way. The court also relied on historical practice. As a general matter, this court spends a lot of time focusing on historical practice when interpreting constitutional rules based on the history of this country. Another good example of that are the recent decisions dealing with the Second Amendment and the right to bear arms, which the court quite recently has said we're going to interpret by looking at the history of gun laws in this country. And so, for example, to know whether or not a statute that purports to restrict the right to carry arms is constitutional, we're going to look to see what kinds of laws were on the books to limit carrying of arms back in 1787. And if we can find analogous regulations, then okay, those can stand. If we can't find analogous regulations, then those probably don't. In this case, the court looked to historical practice of whether state constitutions limited state legislative decisions about elections back in 1787. And the court said the answer is yes. Under the Articles of Confederation, even before the Constitution was adopted, there were several state constitutions that placed limits on the ways that state legislatures could elect members of Congress. And under the new Constitution, the same was true. The best example that I've written down here on the PowerPoint, a number of state constitutional provisions provided that elections must be by ballot. Now, that might seem like a trivial thing to us. How does that significantly constrain state legislatures? Well, it actually turns out that at 1787, there was a real fight as to whether or not elections ought to be done by ballot or they ought to be done in public, in more of a kind of town hall setting where people essentially had to raise their hands and be publicly accountable for their vote. There were arguments that you should have to publicly proclaim who you were voting for so that you took it seriously. But the argument for a vote by ballot was, of course, that you would be less likely to be subjected to peer pressure. Many states ultimately decided it was better to require ballots in order to maintain secrecy, and a lot of those were written into the state constitutions. So the Supreme Court in the Morgan Harper case looked at that and said, okay, so there's history also back on the idea that state courts and the state constitutions can put limits on what state legislatures can do. So then let's return to the text, because of course, the court recently has also frequently said the best evidence of what the Constitution means is the text. And if there's a plain meaning to the text, we're going to follow. So here I'm simply reminding you in red that both of the relevant texts are pretty clear in referring to the legislature. The question is, well, then what does that mean according to the court? And the court kind of just explains it away by saying, well, the state legislature really just means, as I said before, the state lawmaking apparatus as it is defined under state law. So by state legislature, we really just mean by whatever means the state normally makes law, and that includes being limited by the state constitution, and that includes being limited even by vague provisions of the Constitution, if that's what the people of the state have decided to do. Okay. So everything else I've said, or everything I've said so far, makes it seem as though the Supreme Court emphatically rejected the independent state legislative theory. And therefore, we're all done here. We all know now, going forward, that state courts can have the final say as to the meaning of state statutes and as to the constitutionality of state statutes. And all of that would be true if you read the opinion all the way except for the very last part. So we're going to skip ahead to the very last part where the court adds a caveat. Here's the caveat. Court says, although we conclude that the elections clause does not exempt state legislatures from the ordinary constraints imposed by state law, state courts do not have free rein. We have an obligation to ensure that state court interpretations of that law do not evade federal law. Now, what the heck is that? Right? There are other cases where state Supreme Courts interpret state law, and the U.S. Supreme Court says, "Well, wait a minute, we're going to double check you on that." Okay? Normally, the Supreme Court properly says, under our system of federalism, state Supreme Courts are the final arbiters of the meaning of state law. Usually, federal courts don't have anything to say about what state law means. That's up to the state to decide. But there are a handful of cases where the Supreme Court has said, we're a little worried on occasion that state courts might manipulate the meaning of state law to undermine some federal right. And let me give you the most prominent example of that. There's been a worry, this grew mostly out of the 1960s and 70s, about the possibility that state courts, when hearing a state criminal case, and a defendant would raise a federal constitutional right in response, like, the state coerced a confession in violation of my Fifth Amendment privilege against self-incrimination, or the state is introducing evidence that they illegally obtained in violation of my Fourth Amendment right to be free from unreasonable searches and seizures. Or the state court is refusing to let me cross-examine witnesses in violation of my Sixth Amendment right to confront the witnesses against me, right? I, as the defendant, want to raise those federal constitutional claims or analogous ones in my defense. And the state court would basically make up a procedural rule and say, oh, we're not going to let you raise that defense. You waited too long to raise it, or it needed to be in writing and you're only saying it now in open court, or you didn't say it the right way, or some other kind of procedural rule basically saying, we're not even going to listen to your claim of a federal defense. That would be an example where the U.S. Supreme Court would step in and say, we're going to worry that you're tweaking state law, this state procedural law in a way just to screw over this defendant to not give them their federal constitutional right. So in the Moore against Harper case, I think what the court is saying in this caveat is, you know what, we do have to make sure that state courts aren't just making up state constitutional rules so as to override the state legislative judgment about how elections ought to be run. And maybe the fear about why they might be doing that would be, again, because maybe the state Supreme Court has a political agenda. And here's again where we get to the Pennsylvania 2020 allegations that maybe Pennsylvania and a handful of other state Supreme Courts that had more Democratic appointed judges than Republican appointed judges, maybe they were just trying to skew the election rules in a way more favorable to counting more likely Democratic votes in a way that would help Joe Biden over President Trump. That's the deal. Okay. And that's basically captured by this last quote where the Supreme Court says, state courts may not transgress the ordinary bounds of judicial review such that they arrogate to themselves the power vested in state legislatures to regulate federal elections. So the bottom line is the court, having earlier said, hey, whatever the state process is, the state process is, all of a sudden now is saying, maybe not so fast. Maybe we need to worry about state courts becoming kind of too activist or too politicized. How are we going to do that? Well, they go to Bush against Ford. So let's remember what happened in Bush against Ford. You may recall there was a fight in the election, the 2000 election between George Bush and Al Gore over how to count votes in Florida. The Electoral College all came down to Florida. The vote in Florida was incredibly close. There were allegations of problems, hanging chads, if you all remember those things. And the Florida Supreme Court said, we need a recount. Bush challenged the legitimacy of the recounts. That went all the way to this US Supreme Court. And the US Supreme Court decided in favor of George Bush, basically saying there can't be a recount, even though that appears to be what is allowed under Florida state law. Justice Rehnquist said the reason is because the Florida Supreme Court engaged in a quote, impermissible distortion of the state statute. Justice Souter, who disagreed with that conclusion, still allowed for the possibility that maybe the Supreme Court needs to worry about, is there a chance that the state court has, quote, transcended the limits of reasonable statutory interpretations to the point of supplying a statute enacted prior to. Okay, so in Moore against Harper, the court is reverting back to Bush against Gore, the case that frankly many of us constitutional lawyers had always hoped would just disappear from having any relevance, thinking the Supreme Court has no business deciding presidential elections, but now suggesting that the Supreme Court is going to maintain in this limited way some kind of control over state court interpretations of state law that have to do with election rules. The problem is, we don't really know what this means, right? How do we know when the US Supreme Court is going to decide that a state court has, in its view, misread the state constitution or misread a state statute to the level of counting as impermissible distortion or going beyond so-called reasonable statutory interpretations? I was reminded of this cartoon, which I'll let you read for a second. And that's basically what we're engaged in now, is trying to mind read what did the Supreme Court mean when it left open this possibility that it might look over the shoulder of state courts. And we don't know the answer. And unfortunately, we won't know the answer until the next time the court takes a case. And that's really unfortunate because, in my view, the Supreme Court had the opportunity this time to decide the case in a context where the political temperature was pretty low, right? It basically was deciding how to treat a ruling of the North Carolina Supreme Court, one, in a congressional election rather than a presidential one, two, well before any new election was going to take place, and three, frankly, in a case where it didn't matter anymore, because the state court had already withdrawn its objection to the state's districting lines. In other words, it would have been kind of a calm and deliberative opportunity for the court to really answer the question. But unfortunately, now we're going to have to wait until the next chapter, which is most likely going to be right before the 2024 elections, probably will be about the presidential election, which means the Supreme Court's going to have to address this question with very limited time, under a lot of pressure, and where the partisan implications of its ruling are going to be clear for everybody to see. There's going to be clearly one ruling that's going to favor the president, the Democratic nominee, and another rule that's going to favor the Republican nominee, and the court's going to have no way of avoiding the look like back in Bush against Gore, that the Supreme Court is essentially choosing the next president of the United States. Now, that raises us to the question of, did the court get this right or wrong? In my view, you kind of have to choose on a policy basis between the lesser of two evils, right? Either you go along with what the court said and recognize that the Supreme Court's going to continue playing some sort of supervisory role over the process of state rules, which raises the risk that the US Supreme Court looks like it might be engaging in a partisan political fight. Or do what I think they should have done, which is to say, well, we were right to reject the main part of the theory, and we should reject it entirely. We have no role whatsoever in police and state court rules. Does that make it possible that one or more of the 50 state Supreme Courts will be more aggressive than they should, either to favor a Democratic candidate or a Republican candidate? Yeah, it makes it possible, but at least that isn't likely that, or isn't always going to have country-changing results, because it would only be one state at a time and not a new rule for the entire country. So the bottom line is, my view is, the Supreme Court got it 90% right by rejecting the fairly radical and bold proposition that state legislatures control everything, but by leaving the door open for a 10% maybe override, I think it's going to just be in trouble. Keep us in trouble, essentially, over the course of it. Okay. That completes what I wanted to do as a matter of presentation. I'm still having the problem with not being able to get out of screen share. So, Jennifer, I wonder, as co-host, if you're still there, if you could either take that power away or close the screen. Perfect. Thank you very much. Okay. So now I would like to either go to the questions in the chat or open it up more fully. And I should make clear, I'm happy not only to take questions about this particular presentation, but if anybody also wants to talk about the disqualification issue under Section 3 of the 14th Amendment, which is a related but even more novel and important theory, I'm happy to address questions about that as well.
Thank you. The first question we have is, isn't there another case from Ohio for which the Supreme Court of the United States has granted, I'm going to guess here, I had to learn a little bit, certiorari? Thank you. In which the Supreme Court of the United States might revisit the so-called independent state legislature doctrine. How does Moore versus Harper inform us on the issues pending in that case?
So to be honest, I'm not actually familiar with the case that you're talking about. There are cases bubbling up through a handful of state courts. I honestly wasn't aware that the Supreme Court had already granted review in any such case. Now, I didn't look yesterday or today to see if the Supreme Court just announced another list of granted cases. Now that we're approaching the first Monday in October, which is the first day the court will start hearing oral argument, they have started again after the summer recess to grant cases. Maybe if you're willing to re-enter the chat and clarify if you have an answer to that, I'd be happy to address it. But whether it's this case or another case, as I said, the issue will arise. It's just obviously going to be arising. The later the court hears and decides that case, the closer in time it is going to be to the next presidential instead of congressional elections, and therefore the more potentially polarizing any Supreme Court decision will be.
Thank you. The question came from Timothy. I can ask Timothy to unmute in case he has something to add to that. Maybe, Jennifer, are you okay with that?
That's fine.
Hello, Professor Caminker. I just remember I was very excited back in late June when Moore versus Harper turned out the way it did. It could have been much worse. And I was watching a webinar with an advocacy group. I think it was Common Cause, and in that presentation there was a discussion on this case. And it was my understanding that it was another case involving the independent state legislature doctrine that that the Supreme Court had already decided to take up. So it's something that was granted cert for at least a couple of months ago, and that's the vague memory that I have from the webinar that I was watching.
Okay. I appreciate the follow-up. Common Cause was one of the, I said it was voters in North Carolina who had brought that suit. Common Cause represented a group of plaintiffs in that case, although they were not alone. But I'm sorry, I still am not familiar with the particular case that the court supposedly granted. It would be odd for it to have been granted a couple months ago, because that would have been during a dead period in the court's decision-making in the middle of the summer. I wonder if there was maybe just a misstatement on their part. It is possible that what they meant was that the court had previously, to Moore against Harper, granted cert on a different case in Ohio and just held it pending the judgment in Moore against Harper. It's quite common when the Supreme Court is going to decide a particular issue X. If there are other cases bubbling up that also raise issue X, they'll kind of hold them. And then the court will decide the case it took, which in this case was the Moore case. And then it will send all those other cases back to the lower courts for them in the first instance to reconsider in light of what they had just decided in Moore against Harper. Maybe that's what's going on. But I apologize. If you're correct, I'm unfamiliar with that case. And it is possible that maybe they misstated exactly what the procedural posture was and the timing was of that case.
Thank you. The next question is about the Bush versus Gore ruling. Didn't the Supreme Court's ruling on Bush versus Gore explicitly say that it was a ruling not to be used as precedent?
Yeah, kind of. It's a little more complicated than that. The majority of the court in Bush against Gore invalidated the Florida recounts on an equal protection theory, basically arguing that the recount that was going to be set up under state law might count votes somewhat differently in some precincts than in others, right? This is part of the point that states have decentralized political processes, right? And one county may have slightly different recount procedures than another county, and some of them actually have different voting machines, right? Some have certain companies, and some have paper ballots. And there was that whole discussion of the butterfly ballot in Palm Beach, I think it was. So 5 justices actually expressed concern that the recount might be done slightly differently in some places than in other places, so the recount might be done only in some precincts and not other precincts, and that violated a rule of equality. That's the provision, that's the opinion where the court said, but this is a special case. And they had to say that, because otherwise every single election in the country would have been deemed to violate the Equal Protection Clause, because every state uses different procedures within its state, and different states use different ways of counting and collecting and all that kind of stuff. So it necessarily had to say that. The concurring opinion, which is the one that included the language I was talking about, where it was a group of just 3 justices that said, and by the way, the Florida recount also violates the elections clause, or in that case, the electors clause. I don't recall that they were the ones who said, and this is for this case only. So I don't think they necessarily said what they were writing wasn't intended for precedent. It's just, it was only 3 justices. It didn't have any precedential value. Scholars basically scoffed at it. No other court had ever suggested that there was anything to that opinion. And it wasn't until the Pennsylvania, the individual mentions by several justices in Pennsylvania, the cases that came to the court in 2020, that all of a sudden they were talking about Bush against Gore again. So that was kind of a surprise.
Yeah. And we have another question about the 14th Amendment. The 14th Amendment argument for disqualifying Donald Trump involves language which seems so concrete that it makes me wonder, how can this argument fail? What are your thoughts?
Yeah, so I'm gonna have to read a little language. I had it on a PowerPoint, but don't want to go and try and go through back again. Section 3 of the 14th Amendment says, no person shall be ... or hold any office under the United States. That would include no person shall be president, right? If, having previously taken an oath to support the Constitution of the United States, which of course President Trump did when he became president. And here's the operative language. Shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. So that's the operative language, right? You've taken an oath to support the Constitution of the United States, and then you quote, engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. So here's the deal. There's really three different things we need to talk about here, right? The first is, did what Trump did allegedly count as an insurrection or rebellion, or giving aid or comfort to the enemies of the US Constitution? And I'll note that historically, that language was commonly understood to be pretty broad. If we're not talking about just, literally taking up arms and fighting American troops or something along those lines, right? But a whole host of acts that were viewed as obstructing the implementation of federal statutes had long been discussed in the mid-1800s, which is when this language was adopted, as counting as essentially an insurrection or a rebellion. So yes, you might say that language, at least historically understood, would be pretty broad. On the other hand, if you think about that language in the context of more what we think of it as today, there'd be a lot of people who would say, look, maybe the people who actually stormed into the Capitol building engaged in an insurrection or a rebellion, but not somebody who just at worst encouraged them to do so. And then, of course, people can have different views on whether or not, under the facts, President Trump actually encouraged them to do that or didn't, right? So that's a factual question. And then we can also talk about whether or not the strategy of trying to either encourage Mike Pence to unilaterally kind of dismiss some votes from Democratic states, or the whole fake elector schemes, whether that might count as a different form of insurrection or rebellion or aiding the enemies of the Constitution. So that's one question. Second question is, who decides, right? There's no language in this provision that mentions, well, what is the process according to which what person or entity gets to decide if an individual has engaged in an insurrection or a rebellion, right? Now, on the one hand, maybe the right answer is some state entity gets to decide that. That would be consistent with the fact, as we've been talking about from the beginning, that states are actually the bodies that generally get to set the rules for presidential and congressional elections. On the other hand, some people say, well, Section 5 of the 14th Amendment specifically says, quote, Congress shall have power to enforce by appropriate legislation the provisions of this article. So maybe that means that Congress has to pass a statute establishing some kind of process by which people can be declared ineligible because they engaged in insurrection. And arguably, Congress hasn't done this. I say arguably because the one thing Congress has done is Congress did pass a federal statute that is a criminal statute, making it a crime to engage in an insurrection and a rebellion. So maybe you can say somebody who is charged under that statute and found guilty in a court for violating that statute, maybe that counts as satisfying Congress's implementation of this. But President Trump has not been charged under the statute for engaging in insurrection and rebellion. That was not one of the statutory bases for the independent counsel's prosecution of President Trump in the District of Columbia. So unless something new happens, that's not kind of pending. So a lot of people say maybe it's got to be federal courts that ultimately have to make a judgment call about whether or not somebody is engaged in insurrection or rebellion. In the last couple of weeks, a group of voters have brought suit first in Colorado and then, frankly, just yesterday in Minnesota to go to the courts and argue that Trump can't be put on the ballot there by state election officials because he's disqualified under this provision. And that will give an opportunity for courts in those two places to make at least an initial judgment call as to whether or not they want to enforce the provisions of the articles. And if so, on the merits, do they think that any of the activity that President Trump engaged in, whether January 6th or more broadly, counts as an insurrection or a rebellion? So I think you're exactly right that it's a really important question. I don't think that everybody agrees that it's obvious that the acts that he's alleged to have done fall into that category of insurrection. And again, it depends on how broadly or narrowly you define that term. And I think we kind of have to just stay tuned and see what happens there. I will add, there are a lot of people who think even if there is a legal basis for disqualifying President Trump under the 14th Amendment, it wouldn't be a particularly good idea to do so right now. And that might be because the politics of the country as we find them are such that any disqualification of a major presidential candidate for a presidential election under current circumstances will inevitably be viewed as a political act, a partisan act, probably not accepted by people who are supporters of Trump, if that's the direction that the ruling goes in. So there's some question about whether the federal courts themselves might just say, boy, we just don't want to get involved. It would again look like another Bush against Gore, although under a different constitutional provision, it would look like we're making a ruling based on vague constitutional language that inevitably will choose or heavily influence at least who's going to be elected the next president of the United States.
For the next question, has the 14th Amendment ever been used before?
Yeah, it was used twice right after its adoption in, I can't remember if it was the very late 1860s or maybe it was the early 1870s, to disqualify people who had actually been part of the Southern secession as part of the Civil War and had fought on the side of the South. So people who fit the exact historical description of why that provision was added into the 14th Amendment. It was also invoked quite recently, I want to say a few months ago, and I'm not going to remember the exact details, but to keep somebody off of a local election. It was, a state election, some kind of a municipal ballot, based on the fact that the person running for office had actually been engaged in the overrunning of the U.S. Capitol on January 6th, and I believe had been convicted of one or more crimes involved in that. So it was invoked recently, but it was in a minor local/state election, and for somebody who really had participated in January 6th in a much more visceral, tangible way than President Trump is alleged to have done.
Thank you. And then is the treason trial against Aaron Burr a relevant precedent for the disqualification argument?
I only indirectly, and I say indirectly because I suppose I can imagine a court saying the difference between insurrection, rebellion, and treason, that those are close enough that maybe the precedents established under treason kind of bleed over. But I'm not sure that that's right. There are a fair number of state statutes, of treaties, a whole bunch of other places where the exact language of the 14th Amendment, the insurrection and rebellion and the aid and comfort to the enemies, that language actually has a more discrete fixed meaning. And I would think that even a court looking historically to try and figure out what the 14th Amendment means would really look to interpretations of those words and not the word treason, which is a slightly different point. That's a good question.
Yeah, thank you. That's the end of the questions in the chat. Jennifer, I don't know if you want to open up for other folks.
Yes, did anyone else want to ask a question? Feel free to raise your hand, go under reactions at the bottom of the screen. No? Well, thank you very much. This was a really interesting presentation.
Well, thank you again for the invitation, and I hope everybody who's here stays abreast of current events. Clearly, these issues and issues like them are going to continue to be litigated before the courts and fought out in legislative bodies and argued about before election officials. And frankly, there's nothing more important than making sure that we maintain the integrity of our federal and state elections going forward, to make sure that our democracy is on safe ground.
Well, thank you. I hope we can work with you again on another presentation in the future. I thought I saw something coming up in the chat, but no. But thank you. And thanks to everyone who attended this evening. I do have information about next month's program. We are going to have speakers from Pan America speaking on Tuesday, October 10th, on tools and resources for identifying and debunking disinformation. That will be, oh, I don't have that saved here. I thought I did. I usually put that in my document here. So you could get in touch with me at jdye@detroitpubliclibrary.org, and I will be sure to let you know the Eventbrite link. I do have a link to the YouTube playlist, which is dedicated to the League of Women Voters programs. It usually takes a couple of weeks for a recording to be posted there. And then after that, it will be posted at the Detroit League's website. Cheryl, you have a question?
Not a question, but I just wanted to mention that this Saturday at the U of M Detroit base, the university's location on Woodward and Martin Luther King, at 10 or on Zoom, if you're interested, for anyone that you don't have to be a member, is our membership meeting, and Stephanie Chang is speaking at that at the meeting to explain what's going on in the Michigan Legislature. So you're welcome to join us. If you want that information, you can go on the website, which is League of Women Voters .org. I'm sorry, League of Women Voters Detroit.org. So 10 o'clock on Saturday, we usually go till about till 11:30. So thank you.
Okay, thank you everyone for coming. And thank you again, Dr. Caminker, for your presentation. And I will learn to pronounce your name eventually. I apologize. So I hope to see everyone next month.
It was great.
Thank you again. My pleasure.
Thank you.